Today I will discuss indeed interesting cases from the European Court of Justice that were delivered in the past 12 months. We will discuss a different matter. We will not discuss as much the blue card now. I know this morning we've discussed and heard a lot about the blue card, but it has not in the past given rise to many cases from the European Court of Justice. And in my presentation, I will instead focus more on the right to family reunification and the EU long-term resident status. And so when I was invited to present today, I was offered to discuss three cases to relate to family reunification, and in particular, the right to family reunification of refugees, and one case about the loss of the EU long-term resident status in case of intra-EU mobility. And I will start with the Afrin case that was delivered exactly 1 year ago on the 18th of April 2023. And the name of the case is coming from a city in northwestern Syria. And the case concerns family reunification with a refugee from Syria. The father traveled from Syria to Belgium, where he obtained international protection, and then subsequently his wife and 2 children have applied for family reunification to Belgium. But like I said, this family is from the northwest of Syria. You can see here Afrin with the little red dot on the map, which is a small town stuck between Aleppo and the Turkish border. And actually this place is ruled by the Turkish army. And it's very difficult for the family members to travel to a Belgian consulate, either in Turkey, because Syrians now need a visa to travel to Turkey. The family members could not obtain such a visa, and Belgium does not have an embassy in Syria. So the other option would be to travel to Lebanon, to Beirut, which was, because of the war, very difficult. And so the father went to a lawyer here in Brussels, actually one of my very close colleagues, and they've submitted an application for family reunification by email. And so they sent all supporting documents to the immigration office, saying it's impossible for family members in Syria to travel either to Turkey or Lebanon. So instead, we will apply by email because of the war and the impossibility to travel abroad. Of course, the immigration office in Brussels replied a few days later saying this is not allowed according to the Belgian legislation. The family members have to apply in person at a consular representation in the region, either Beirut or Ankara, since there's no embassy in Damascus or Aleppo. And the immigration office in Belgium relied on Article 5 of the EU Directive on Family Reunification that provides that member states have to determine whether, in order to benefit from the right to family reunification, the application is to be submitted either by the sponsor, so in the destination country, or by the family members abroad. And I think in the majority of member states, they've chosen that the family members abroad have to submit the application. And so basically the sponsor, as it is the case in Belgium, can help and prepare the application. He can prepare all the documents, but it is the family members, so here the wife and the 2 children, that have to apply abroad for family reunification. And under Belgian legislation, there is no derogation, there is no exception, even in the case of war or difficulty to travel to the relevant embassy. And so the lawyer basically went to court here in Brussels, arguing that this was a disproportionate obstacle in the exercise of the right to family reunification. And the court in Brussels agreed with the applicant that indeed his wife and 2 children cannot go to Turkey or Lebanon, and that basically in practice it's impossible for them to cross the border or to cross Syria to go to Lebanon. And so the court then referred the case, asked a question to the Luxembourg court, asking whether the Belgian legislation and practice was in line with the directive of 2003-86. Of course, then the court recalled Article 5 of the directive, and indeed member states have to decide who and where the application is to be filed, and Belgium can decide that it is for the family members abroad to file the application. Nonetheless, this cannot undermine the objective of the EU directive, which is to promote family reunification. This is very well established case law, the Chacron case, and this objective to promote family reunification is especially strong for refugees because they cannot exercise the right to family life in the country of origin because of the risk of persecution. And so member states have to promote the exercise of the right to family reunification. And then in the decision, the court found that in case of conflict, where it's very difficult to move or to cross border to apply for family reunification, flexibility is required in order to allow family members to benefit from the right to family reunification. Otherwise, basically families would be separated for forever or for a very long time. And also refugees, family members of refugees would be at risk of missing the deadline. As you know, in many member states, there's a deadline to benefit from a more favorable treatment. In Belgium, it's 1 year. In many other member states, it's 3 months. And beyond that time, the usual conditions, socioeconomic conditions, have to be met, which makes it very difficult for family members of refugees to benefit from the right to family reunification. And so the Court of Justice here agrees that the application of the law in Belgium makes it impossible in practice for the family members of the applicant to benefit from the right to family reunification. And such an application is disproportionate with the objective to promote family reunification. And so the court basically agrees that the family members should be allowed to apply by email, and that the authorities in Belgium have to be flexible in registering the application for family reunification. Yet they can require the family members to travel to the embassy or the consulate, but only once, and preferably at the last stage when they receive the visa. And so the application can, at the beginning, be introduced by email. And I just want to quote a paragraph from the opinion of Advocate General Pietruzzella, with whom I fully agree. And the quote goes as follows: "It should be noted that the right to that the reunification procedure takes place in stages and often requires, after the application has been submitted, that the family members concerned present themselves at a diplomatic or consular post several times, in particular in order to lodge documents, to be interviewed, to undergo DNA tests, and if the application is accepted, to collect visa. Requiring those persons would generally include the most fragile members of the family, such as young children, to make multiple, often long, difficult, if not plainly dangerous or excessively onerous journeys to diplomatic or consular posts, which may, as in the main proceedings, be located in countries other than the country of residence, in order to complete the formalities, which can easily be completed at a distance and here online, does not seem to be, to me, to be consistent with the spirit of the directive, but seems rather to stem from a desire to place in the path of family reunification obstacles of such a kind as to discourage the exercise of the right to such reunification. And here, I fully agree as a practitioner also of immigration and asylum law in Brussels that indeed procedural obstacles are very significant in practice. And basically, some of our clients, even if they meet the conditions for family reunification, they simply cannot access these rights because they cannot go to an embassy, Belgian embassy, often located in a different country. Of course, Belgium is a small country. We do not have an embassy in every country, especially not in countries at war, where refugees usually come from. And so I think this Afrin case is a very good example of strategic litigation. And so through an individual case, we can bring about structural change in how the procedure is made. And I think a good illustration of this is how some other member states, such as France, Germany, Spain, and the Netherlands, joined the proceedings in support of Belgium, obviously. And it really shows how the procedure is really constraining in practice. And I think that the findings of this case could be also applied for, obviously now for individuals from Palestine, from Gaza, Sudan, Eritrea. All of these people need to travel to other countries to apply for family reunification, because Belgium do not have embassies there, but also Afghanistan, for instance. So in practice, it has had quite a big impact, and I think in the future it will have also more impact, and I hope it will also have an impact in other member states other than Belgium, and maybe also beyond family reunification, but maybe also for labor, immigration, or study visa. Once again, applicants need to go to an embassy, sometimes multiple times, although they could probably apply by email. I will now move to the second case, which is coming from the Administrative Court of Vienna. It is also relating to the right to family reunification of a family of a refugee. Here, it's also a family from Syria, where the sponsor left his country, Syria, and arrived in Austria, where when he was 16. And then he obtained international protection in Austria a year later. So he was still a minor when he obtained international protection. Subsequently, the parents, mom and dad, but also the sister, who was severely ill, applied for family reunification. I learned that Austria has an embassy, or at least had an embassy in Syria, so they were allowed to apply directly from Syria. But the application was nonetheless rejected on the ground that the sponsor, so the minor at the time, turned 18 during the family reunification procedure. And so the Austrian authorities considered that the applicant was not allowed to be reunited with his parents. Such decision is a bit surprising. It's a bit striking because it is not in line with the case law of the Court of Justice. I think already in 2018, in the ANS case, the Court of Justice made clear that the applicant remains a minor, even if he or she turns 18 during the asylum procedure. And so this finding should also be applied if the sponsor turns 18, not only during the asylum procedure, but also during the subsequent family reunification procedure, as was the case here in this case, delivered on the 30th of January 2024. And so I think the Court of Justice already delivered quite a few cases where it said clearly that the minor, the person remains a minor, even if he or she turns 18 during the asylum application or the application for family reunification. And so basically the relevant date is the date at which the applicant applied for international protection. Otherwise, it would be unfair and unequal, because authorities may take 1 or 2 or 3 years to decide on the asylum application, and then the family reunification procedure can take up to 9 months. So basically, a lot of minors would not be allowed to be reunited with their parents. And so the date to be taken into consideration is the date of the application for international protection. The court here recalled this principle. So the applicant is to be considered a minor. And the court also clearly said that no deadline can be applied since the sponsor is a minor. Here, the minor applied for family reunification before he turned 18, and his parents were allowed to come, even if he applied 3 months plus 1 day after he obtained protection. Because in Austria, you have to apply within 3 months to benefit from the more favorable treatment as a refugee. But the court said, since he's a minor, there is no deadline applicable to him. However, if he had turned 18 before the application for family reunification, then the authorities must give a reasonable time to apply for family reunification. The court from Austria actually asked, I think, 7 questions. So there was also a question about who can benefit from the right to family reunification. Since the sponsor is a minor, it is clear that the parents, mom and dad, can come because they are the ascending parents. The legislation is clear, but the sister, who was also above 18 at the time, was not allowed to come to Austria. But like I said, the sister was severely ill and she was completely dependent on the assistance from her parents. And then the court, the administrative court of Vienna, was asking the Court of Justice whether the sister should also be allowed to enter Austria and receive a visa, since she is completely dependent on her parents. And so basically, if the sister was not receiving a permit, the parents would not come, and the sponsor, the minor, would not enjoy family reunification with his parents. And so basically, there was a derived right to family reunification for the sister, because otherwise the parents would not be coming to Austria. Finally, the court also answered some questions regarding the material conditions and the substantive conditions for the right to family reunification. As I said, refugees usually enjoy more favorable treatment, but they need to apply within a given deadline. And this deadline is depending on the transposition measure in every member state. In Belgium, it's 1 year, but the minimum is 3 months. And I think in Austria, it is indeed 3 months. And so if you apply after 3 months, you need to meet the usual conditions, having sufficient accommodation, means of subsistence, and healthcare insurance. And here, the court recalled that for minors, those conditions cannot be applicable. And so in this present case, since the person was a minor on the day he applied for asylum, he cannot be expected to have means of subsistence. And so he does not need to apply to meet those socioeconomic conditions to be reunited with his family. As the European Commission said during the proceedings, it is practically impossible for an accompanied minor to have, for him or herself and the members of his family, accommodation, sickness insurance, and means of subsistence to meet the conditions defined in Article 7 of the EU directive. Likewise, it's extremely difficult for the parents of the minor to meet those conditions before having joined their child in the member state concerned. Therefore, to make the possibility of family reunification of an accompanied minor refugees with the parents, dependent on compliance with the said conditions, would in reality be tantamount to depriving those minors of the right to such reunification, which would be in violation of the Charter. And so basically the Court of Justice recalled that minors cannot be expected to have means of subsistence, sufficient accommodation, or sickness insurance. And I think overall this case is very interesting. Also, it was delivered by the Grand Chamber, so it shows that it's an important case. And I think it really recalls all of the principles established by the Court of Justice in the past few years regarding the right to family reunification in general, but also of refugees in particular. And so for minors, so that is for people that apply for international protection before they turn 18, even if they turn 18 later on, no material conditions can be expected. For adults, they benefit from a preferential treatment if they apply within deadline, like I said, depending on the member state's transposition measure. But for the other adults, they need to comply with the income, health insurance, and accommodation conditions. So it's quite a technical case. There were 7 questions asked to the court, but I think it's a very good summary of what is the different regimes for family reunification of refugees, and it makes a good summary of previous case law. And now I will turn to the last case, which is about the EU long-term resident status. This case is actually very interesting, and I think it's the first case delivered by the Court of Justice relating to the loss of this EU long-term resident status in case of intra-EU mobility. And there were 2 questions referred to the court from 2 German courts. And they relate to 2 applicants who obtained the EU long-term resident status in Italy. So they have lived there for at least 5 years before moving to Germany and exercising the right to intra-EU mobility according to the long-term residence directive. They lived in Germany for quite a few years, at least 6 years. And at some point, German authorities have decided not to renew their permit to reside in Germany on the ground that they have remained in Germany for more than 6 years, meaning that they had lost their long-term resident status in the first country, in Italy. And indeed, you can lose the EU long-term resident status if you move to another member state. And here I just want to recall Article 9, paragraph 4 of the long-term resident status directive, which says that the long-term resident who has resided in another member state in accordance with Chapter 3 of the directive shall no longer be entitled to maintain his or her status acquired in the first member state when they acquire the same status in another member state. So basically, you cannot be long-term resident in 2 member states. You only have the status in 1 country. But in this case, the applicants did not obtain this status in Germany. However, German authorities relied on the second sub-paragraph, which says, in any case, after 6 years of absence from the territory of the member states that granted the status, so here, Italy, the person concerned shall no longer be entitled to maintain his or her long-term resident status in the said member states. And German authorities relied on this provision, saying, you've been living in Germany for 6 years, meaning you were absent from Italy for 6 years. And as a consequence, you lost your long-term resident status in Italy. And obviously the consequence is you're not allowed to remain in Germany any longer. And I think indeed it's the first time the Court of Justice was asked to interpret this provision And it has to be distinguished from another case from Austria that was delivered 2 years ago, which was relating not to intra-EU mobility and the loss of the status, but the loss of the status in case of return to the country of origin. And that was the Landeshauptmann von Wien case delivered in January 2022, where the applicant was from Kazakhstan, obtained EU long-term residence status in Austria, then returned to Kazakhstan, and a few years after he tried to renew his permit, but Austrian authorities have said that he lost the permit. And the Court of Justice said, you only lose the permit if you do not come to the EU over 12 consecutive months. And the court precised that if you do come to the EU, any country, not necessarily Vienna, Austria, you do keep the permit and in your status, even if you come only for a few days to the EU. And so basically, once you obtain the status, return to your country of origin. If you come even on vacation for a few days on a given year, you do not lose the EU long-term status. But this case is different because it's not about returning to a third country. It's about moving within the EU, and I think it's the first time the Court of Justice ruled on such a scenario. So what has the court said? The court basically said that the intra-EU mobility provision is only, you can only exercise this right if you have obtained the long-term residence status in the first member states. And so you can only move here to Germany if indeed you have obtained long-term residence status in Italy. And when issuing a residence permit or renewing the residence permit, the second member states can check, of course, if the applicant still possesses or holds that permit in the first member state. And so to issue a residence permit, the authorities in Germany have to check whether or not the person holds the long-term residence status. That's quite obvious. And then, of course, it allows the authorities in the second member state to make sure that the person did not lose that permit in the first member state. However, it is not for Germany to withdraw the residence permit acquired in the first member state. In this case, only Italy can withdraw the permit they have issued to the applicants, and it's not for Germany to take away the permit. However, it is correct that if the persons have lived in Germany for 6 years, there's a good indication that they've not resided in Italy for at all in the past 6 years, and that as a consequence, they may have lost their permit in Italy. Nonetheless, the Court of Justice imposed 2 further checks on the authorities in the second member state, so here Germany, and they have to make sure that the applicants have not been physically present in the first member state at all in the past 6 years. And the court, a bit like the previous case about the Kazakh national, said if the applicants have been at least even just a few days have been physically present in the first member state, so here Italy, basically the 6-year deadline goes back to 0. And so even if they went on vacation to Sicily, there's a new 6-year period that starts over again. And so it is for German authorities to make sure that the applicants have not been at all to Italy in the past 6 years. And also the authorities in the second member states have to make sure that the first country has not provided for any derogation from this 6-year deadline. So in some cases, member states may be more generous and provide for a longer period or provide for some derogations. And then it is for the second member state to make sure that there are no derogations in the legislation of the first member state. If those checks have been made, and if there's no derogation in the domestic legislation, and if the applicants have not been at least even a few days in that country in the past 6 years, which, I mean, seems a bit unlikely. The second, member states can refuse to renew the residence permit, but only under those conditions could Germany decide to not renew the residence permit. And so it is for the domestic courts to assess whether or not these conditions are met. And so I think it's a very interesting case. There have not been so many cases on the EU long-term resident directive yet. I know, and we heard that there's a proposal on the table to reform this directive. God knows if it will be approved and agreed in the months to come. But for the time being, this directive will probably give rise to more cases from the Court of Justice. And I think we will have more cases in the months to come. And actually, when I was preparing, I saw that last month, the Court of Justice delivered another case on this directive, also in case of intra-EU mobility. But maybe this could be something to discuss next year at the next conference. But for the time being, I will stop here. Thanks again very much for having me. And I would be very pleased to answer any questions you have before the lunch break. Thank you very much.